Good morning, this is your Kelso Report for Thursday, December 15th, and I'm your host, Clerk Kelso. Well, our featured case today is in the area of the law of torts. Take you back to first year law school. In Gonzales versus Southern California Gas Company. In an opinion following a transfer from the California Supreme Court, the 4th District held as a matter of law that the defendant gas company did not owe a duty to the driver of a car on a street with respect to the location of a gas meter assembly that was located 11 feet beyond the street curb. The decedent, a 17-year-old girl, was driving home from work in her Ford Escort at about 25 miles per hour. When another vehicle apparently attempted to pass her vehicle on its right side, her vehicle drifted to the left into the eastbound lane, and apparently in an attempt to avoid an oncoming car, she swerved, causing her car to jump an 8-inch street curb. Continuing at a speed of about 25 miles per hour, her vehicle apparently rotated counterclockwise and struck and bounced off of a perimeter block wall. As the truck continued to rotate, it struck a steel post which had been installed in front of the gas meter assembly to protect the assembly from damage from low-speed impacts. The steel post was knocked onto the meter assembly. A spark ignited gas that escaped from the high-pressure side of the assembly and its ruptured gas line, and that caused a fire that engulfed the truck. Tragically, the driver was burned over 80% of her body and died 2 days later. The 4th District applied the factors from California's leading duty case, Rowland versus Christian, and concluded that the defendant did not owe a duty to the driver because, among other things, it was not reasonably foreseeable that the category of conduct consisting of the installation of a fixed object on private property, a substantial distance from a straight, level, and curbed public street, with a 25 mile per hour speed limit, would cause injuries to an occupant of an errantly driven vehicle. Now, in reaching this conclusion, the court distinguished the California Supreme Court's recent decision in Cabral versus Ralph's Grocery, where the court held just earlier this year that a truck driver who pulled his truck off of a high-speed freeway to the shoulder to have a snack in an area marked for emergency stopping only did owe a duty to drivers on the freeway, such that the truck driver could be held responsible in a wrongful death action when a car veered off the highway and crashed into the back of the truck. Cabral was distinguished on the grounds that it involved duties of care owed by someone who had inappropriately stopped his car on the shoulder of a high-speed, uncurbed freeway, whereas the case before the 4th District involved a low-speed residential street with a curb and a variety of objects located more or less near the street all along its length. This case had been sent back to the 4th District for consideration in light of Cabral, so the California Supreme Court will undoubtedly take a close look at the 4th District's opinion. My guess is that the 4th District has it right, and the California Supreme Court will deny further review. Tort duties do not extend to infinity, and the 4th District's analysis seems pretty solid to me. And now our one-liners. First, to the area of habeas corpus and duties of state prison officials. In Allston versus Reed, the 9th Circuit held that state prison officials did not have a clearly established duty to seek out original court records to determine whether petitioner was being over-detained. This is a holding that ultimately extends the protection of qualified immunity to the state prison officials in a Section 1983 action against them. The petitioner was first sentenced to prison in 1991 and then sentenced additional time for a new crime by a court judgment issued November 20, 1997. A few weeks later, the court issued another order providing that the new sentence was to run concurrently with any other sentence the defendant was already serving. Unfortunately, that second order was never received by the Corrections Department. Some 8 years later, the department discovered that it had been improperly treating two separate sentences as though they were to be served concurrently as a general matter, when state statutes actually provided that such sentences were to be served consecutively, absent a contrary court order. Well, as a result, corrections officials went through all of their records of all of their prisoners, and they sent a letter to the petitioner indicating he had a new release date that extended his stay by several years. The petitioner complained that he was being over-detained, but he never told correction officials that there was a second judgment specifically providing that the 1991 and 97 sentences were to be served concurrently. In fact, the petitioner himself was even unaware of the second order in 1997 and discovered it only after his release. Well, in these circumstances, the Ninth Circuit held that there was no clearly established duty to independently seek out original court records to determine whether petitioner was being over-detained. Next, in the area of civil procedure, in Voigt versus Montano, the 6th District issued a writ of mandate directing the court clerk for the Superior Court of Santa Clara County to accept for filing the petitioner's motion requesting the appointment of counsel in a civil case, because the petitioner said, "I'm incarcerated and I'm indigent." The court clerk, surprisingly, had returned the filing to the petitioner several times. Now, the first time it was for procedural reasons, but subsequent refusals to file seemed to be based on the court clerk's judgment on the merits. For example, the court clerk indicated in one letter refusing to file the complaint that, quote, "The court does not set a hearing for a request for the appointment of counsel on a civil matter. You need to find a counsel on your own to represent you," close quote. Well, the 6th District held that the clerk's office's actions violated the petitioner's rights under both the federal and state constitutions of access to the courts. The court clerk's supposed to file complaints, not rule on the merits. Next, in the area of arbitration, in Bayzone versus Castle in Cooke, California, the 5th District held that the construction contracts between the parties, pursuant to which petitioners' homes were built, contained valid clauses that took the contracts out of the scope of California's statutory pre-litigation procedures applicable to construction defect actions. And they also contained non-statutory arbitration clauses that were enforceable as a matter of contract law. And as a result, the builder was not required to follow the statutory notice and mediation procedures set forth in California's construction defect statutes. Next, in the area of inverse condemnation, in Avenida San Juan Partnership versus City of San Clemente, the 4th District concluded that the City of San Clemente had engaged in illegal spot zoning of the plaintiff's property, since the plaintiff's property was zoned for 1 dwelling per 20 acres, while every property around the plaintiff's property was zoned for at least 4 dwellings per acre. And there was no special topography or condition on the plaintiff's property justifying the discriminatory treatment. So the court affirmed a conditional judgment giving the city the choice of either changing the zoning to 4 dwellings per acre as requested by the plaintiff, or paying inverse condemnation damages measured by the difference in market value. And that's it for today's Kelso Report. Have a great day in the law.